What is a de facto partnership or an accidental partnership? That's when two people carry on a business as co-owners for profit. They don't do any registration. They've never set up a formal partnership. They don't have an LLC or an S corporation or a C corporation. Instead, it's two people who are working in business together for profit. The law says that if you do that, you are in a partnership. It's often called an accidental partnership or a de facto partnership because the people don't realize all of a sudden this happens. Now, when does this happen? Well, this might be two people who are working together on a business. That's a simple example. It also often arises when two companies work together. Now, what happens if you have a contract? It's possible that contract would clarify that this is not a partnership, and an attorney could make sure that it doesn't have the elements of a partnership. But it's important to remember that where two people or two organizations or two companies are working together as co-owners, sharing the profit, that can be deemed a de facto partnership or an accidental partnership under Minnesota law. This is a common law partnership. It's not a registered partnership. It's not a limited partnership. And why does this matter? Because the partners are personally liable for the acts of their other partner. In other words, you might find yourself personally liable for that which your other partner does. And since there's no limited liability, this isn't a limited liability company, also known as an LLC. It's not an S corp. So since there's no limited liability, you are personally liable for the acts of your partner. That's a big deal. That's why whenever you go into business with somebody else, you should consider whether it makes sense to set up a business entity that will limit liability. Generally, that's going to be an LLC or a corporation. I'm Aaron Hall, a business attorney in Minnesota. For additional information, see the links below.